Hello and welcome everybody to this morning's if you're on the West Coast, or this afternoon's if you're on the East Coast, continuing education webinar on the topic of acting now and reaping later, more so preparing for an upcoming office lease renewal, a veterinary office lease renewal. Really what the focus today for today's continuing education webinar will be on ensuring that we are proactive as it relates to the office lease agreement and any upcoming lease renewals, or preparing for transition, and ensuring that the lease agreement is properly structured to support those endeavors. I would encourage all of you who are on the webinar today, if you have a copy of the lease agreement handy for the clinic, I would recommend grabbing a copy quickly and taking some notes as we go through the topic for today and the slides moving forward, so that when we touch on specific items, you can look into your own lease agreement and ensure that those articles are properly structured to support you and the clinic in your goals moving forward. So I will let anyone who is joining us currently, take a minute to, if you do have a copy of the lease handy, grab a copy of that, or otherwise grab a pen and a piece of paper and certainly take some notes as we go through these slides today. My name is Brendan Madden. I will be your lecturer today. I am a senior consultant here at Cirrus Consulting Group, and really what it is, so that you know who it is that I am and what it is that I do on a regular basis. Almost daily I strategize, consult, and discuss with doctors across North America the best route to either starting a new clinic and ensuring that the lease agreement is properly structured, doctors looking to renew a lease agreement and enter into negotiations to ensure more favorable terms in that clinic lease agreement, doctors who are looking to potentially expand the clinic or relocate the clinic. The lease agreement has an impact on both of those initiatives, so it's important that we familiarize ourselves with the lease agreement and those items which are included within as we go down the route of either relocating or expanding a clinic. And finally, I discuss and strategize with doctors who are looking to transition from veterinary medicine and ensure that the lease agreement is properly structured to support that endeavor. Now, the goal for today's continuing education webinar is really so that all of you leave here with a better understanding of the importance of the veterinary office lease as it relates to you and the clinic. Excuse me one second. Right, so really the goal for today is to give all of you a better understanding of the importance of the veterinary office lease agreement and why it's so critical to be aware of your relevant dates within the lease, such as the expiration date, any option to renew deadlines within the lease agreement, as well as being proactive with regard to your lease negotiations, whether they be, fairly time sensitive or in the next few years you have a lease coming up for renewal. It's extremely important that we're being proactive and we have all of our ducks in a row prior to engaging in negotiations with the landlord during that renewal period. On the agenda for today, we will be discussing a number of items as they relate to your veterinary office lease. to begin with, we'll begin to discuss some of the dangers inherent in missing your renewal or expiration date for your veterinary office lease agreement. We'll walk through the tenant lease cycle to give you a real understanding as to the best time to begin preparing for negotiations, as well as the best point where you have the maximum leverage to pick up the phone and actually begin those negotiations with your landlord. We will provide some tips on bringing the landlord to the negotiation table when you're ready to discuss the renewal of your lease agreement. Typically, and as we will touch on a little further into this presentation, landlords will attempt to delay the process of renewing a lease and negotiating the economic and legal terms of the lease agreement strategically for a number of reasons. So it's important to be aware that the closer that you get to an expiration date or a renewal deadline, the more leverage the landlord has in their court during the negotiations, because most, if not all, landlords are fairly savvy when it comes to business, and they understand that a veterinary clinic takes some time, a significant period, to relocate if that is the route that we have to go down. So the closer we get to a renewal or an expiration date, the landlord is aware, and therefore it's important to get them to the negotiation table proactively and when you have the maximum amount of leverage on your side of things. We'll walk through some of the articles that you will find in your lease agreements, your specific lease agreements, and I'll walk you through how we go about analyzing some of the language within those articles, the legal articles in the lease agreement, in order to identify potential risks, potential traps, but also potential liabilities and opportunities for you and the clinic moving forward. As well, we're going to touch on some business-shattering clauses that can significantly impact your flexibility for a renewal of the lease agreement and significantly hinder your long-term plans. Now, we will get into it a little bit further, but I wonder if anyone has mentioned to you that the lease agreement really can dictate 100% if you are able to sell the clinic when you look to transition and how that sale and transfer process will occur. Before we do jump into the meat of today's presentation, I wanted to give a little bit of a background for those of you who are not familiar with Cirrus Consulting Group, or those of you who have not joined us for a continuing education course in the past. I thought it would be beneficial to provide you a quick overview on who Cirrus is and what it is that we do on a regular basis. Cirrus Consulting Group was founded by healthcare professionals for healthcare professionals back in 1994. So we have been in business now just about coming up on 24 years. We are a tenant representation firm, and we represent healthcare professionals in commercial real estate matters, but primarily the negotiation of office lease agreements. What makes Cirrus a little bit unique is we do here have an in-house legal team comprised of real estate attorneys who all have backgrounds in healthcare and tenant representation. We also in-house have a leasing team comprised of former commercial real estate brokers and analysts And they're the team that are able to provide us with in-house market research, comparable rental rates, property availabilities, and landlord research across North America. And finally, we have our in-house consulting team, of which I am one of our senior consultants. And again, what it is that we do is strategize and consult with doctors looking to start a clinic and ensure the lease agreement is properly structured, renew a lease agreement and enter into negotiations with their landlord, and doctors looking to transition in the next few years who need to ensure that the lease is properly structured to support that endeavor. On an annual basis, we analyze thousands of healthcare lease agreements. Just last year, we represented over 1,000 practitioners, which includes doctors who own the building out of which they house their clinic or practice veterinary medicine, right? Owner-occupiers as well as tenants. Throughout our over 2 decades of experience, we have negotiated over 10,000 office leases. And we do conduct over 150 educational seminars annually and participate in many veterinary conferences across North America. And finally, we are the premier healthcare tenant representation firm for veterinarians all across North America. The slide that you see in front of you currently shows some of the recent doctors that we have worked with on their lease negotiations. The reason I like to present this slide is because it really provides a picture that veterinary lease issues don't solely exist in large urban areas, perhaps where the rent is higher relative to the country. These issues are found in the significant majority of veterinary office leases across all of North America. And therefore, no matter if you are in a smaller rural community or, in the center of an urban area, it's important to familiarize yourselves with the contents of the lease agreement, most importantly, the legal terms and provisions that you are bound by under the lease, and not solely focusing on the rental obligations and the term of the lease agreement. So what is a lease agreement? I like to pose this question, and I'll give you all a moment here to think about it for yourselves and to develop your own opinion and point of view as to what is a lease. Typically, when I'll pose this question in a live seminar presentation, I will get a few common answers. Those answers are typically, a lease is a contract. It is an agreement. It is a marriage, for example, between the tenant and the landlord. Now, these answers, of course, are all correct, but the first thing that I look at when I see a lease agreement really is what you see here in front of you. The lease agreement is a check. And likely for most of you or some of you, the largest check that you will have ever signed in your careers or perhaps even your lives. Right? For the sake of simplistic math, let's use an average rental rate of about $5,000 per month. Now, some of you may be paying less than $5,000 a month. Some of you may be paying more than $5,000 a month for your rental obligations. But as a ballpark example, let's use $5,000 per month in rent multiplied by 12 months in a year gives us about $60,000 worth of rent per year that we're paying to the landlord. Typically, and it does differ case by case, but in most cases we will sign a 10-year initial lease agreement. That brings the total amount that we will pay in rent through the life of that lease, not taking into account any increases in rent throughout the life, to $600,000 over a 10-year period, right? And if we project that forward 20 years, that is now a $1.2 million check that you have signed. And for, the majority of you, we may approach practicing for about 30 years or so throughout our entire careers. Perhaps less, perhaps more, but throughout a 30-year lease agreement, we end up paying rent of about $1.8 million if we are paying about $5,000 per month. The reason I like to provide this example is, although we need to keep and would like to keep our rent as low as possible under the lease agreement and for the life of the lease and our careers as a veterinarian, do you think that all of you may have paid a little bit more attention to those other 40, 50, 60 pages, 100 pages in some instances of the lease agreement following those basic provisions which outline the rental rates and the term of the lease? It's so important to familiarize yourselves with those other pages of the lease agreement, the legal terms and provisions that you are bound by under the lease. I would encourage all of you, take some time to really look through the lease agreement, pull out a highlighter, and walk yourself through some of those articles, especially the articles we discussed today, but walk yourself through the entire lease. And if there's any potential red flags that you spot, highlight that and bring it to the attention to someone who is familiar with what the implications of those articles may be. So why is the veterinary office lease agreement so important? Well, one of the main reasons that the lease is so important is the significant investment and cost that it takes to enter into the business of veterinary medicine. We make significant investments in most cases into the clinic in which we practice. It's extremely difficult and also time-consuming to move a clinic once it has been built up and running for some time. If we do ever need to relocate a veterinary clinic, what type of patient attrition will we experience? And finally, as I have touched on, the veterinary lease agreement can dictate your ability to sell the clinic, to sell the practice. So it's extremely important that, again, we familiarize ourselves with how our veterinary lease is structured, and we ensure that it is going to support our goals, both short-term as well as long-term. If we do structure a properly negotiated lease agreement, what are some of the benefits that arise because of such? Right? I like to say that if a lease agreement is properly structured and properly negotiated for a veterinary clinic, it ensures that the lease, when you look to sell the clinic, will act as an asset as opposed to a liability. Unfortunately, in a lot of the lease agreements that we review on a daily basis, the majority of them act as liabilities for the doctor, where a few tweaks to some of the articles and language within the lease could ensure that it acts as an asset and increases the clinic's sale value when we do look to transition from veterinary medicine. One of the benefits are fair and affordable financial terms. Typically, a general rule of thumb is we'd like to ensure that our occupancy expenses, right, the rent and maybe additional rent that we pay under the lease agreement, represent about 8% of our overall practice production, right? So something to keep in mind. If our occupancy expenses, if our rent expenses and outlays on a monthly or annual basis are greater than 8% of our total production in the clinic, we need to begin thinking, first of all, is our rent too high for the market? We need some research and some comparable rental rates so that we can determine, is our rent fair and affordable? If the rent seems to be in line with the market and our occupancy expenses are greater than 8% of our overall production, well then the individual doctor needs to decide, is there something that I can do to increase the patient flow and the production in the clinic to ensure that those occupancy expenses meet that roughly 8% of production threshold. A properly negotiated lease agreement will also provide you with long-term stability and security, peace of mind in the space out of which you practice. Typically, when we represent doctors, and it is case by case, but in most cases, we will ensure a lease agreement that has an initial term of 10 years with multiple 2, 3, 4 options to renew the lease agreement. In order to provide long-term stability and security within the clinic, if we're able to secure a 10-year initial term with multiple 5-year options, we can guarantee ourselves that we have the right to that space for a minimum of a 20-year period. A properly negotiated lease agreement should also minimize any personal risk and exposure that you have under the lease. Ideally, for all of you who are joining us today, the lease agreement is signed under a corporation, a corporate entity, a PLLC, an LLC, a PC, some type of corporate entity, and ideally none of you in attendance today are on the lease agreement personally. The reason we look to ensure it's a corporate entity on the lease as opposed to the doctor personally is in the event of any dispute with the landlord regarding rent or any of the legal terms and provisions under the lease. If you only have your corporate entity on the lease agreement, the landlord's sole recourse is to that corporate entity, and therefore they cannot come after your personal assets, your family's assets, your home, your car, and your investments, etc. Okay, so ideally we provide no form of a personal guarantee under our lease agreement, and it is solely the corporation that is listed on the lease in order to minimize or completely eliminate any personal risk and exposure that we have under the lease. A properly negotiated lease agreement needs to maximize your flexibility and will do so. One of the examples I like to bring up when discussing flexibility under the lease agreement is an article entitled the Death and Disability Provision. Now, to some of you, it may seem a little bit morbid, but it's important that you all have a death and disability provision in your lease agreement. God forbid something were to happen to any of you and you were to become sick, injured, or God forbid pass away. It's important that you or your estate has the right to terminate the lease agreement and not have to continue to pay rent for the life of the lease if you are no longer able to practice veterinary medicine. If all of these are properly negotiated into the lease agreement and we have a well-structured veterinary lease, again, it will enhance your ability to eventually, when you're ready to sell the clinic, it will ensure that you have a smooth transition, and it will often increase the value we're able to obtain for the sale of the clinic. Now, some of you may be asking or have thought about it in the past, what happens if I miss my lease expiry date? Well, in, if not all of yours, the majority of your lease agreements, there should be an article which is entitled overholding, or in some cases, holding over. This is the provision in your lease agreement that would dictate what occurs if you miss your lease expiry date. What happens if you become a quote-unquote month-to-month or overholding tenant? Well, in the majority of cases under your lease agreements, what that means is the landlord has the right and the ability to double your monthly rent. So that $5,000 example now increases to $10,000 per month, and you can imagine what that may do to the clinic's numbers. It would also mean that the landlord has the right to terminate the lease agreement and evict you from the space within 30 days' notice. So for all of you joining us today, it's extremely important that you are aware of those critical dates under your lease agreement. When does the lease expire? When do we need to provide notice for the renewal of our lease? Right? If we miss the expiration date, and unfortunately we experience this more often than I would like to admit from your colleagues across the country, and we are evicted from the space, the cost to demolish, renovate, relocate, and rebuild a veterinary clinic from scratch, as most of you are aware, can easily cost $200,000 or more, right? And you can imagine if we only had 30 days to relocate a clinic, we may face significant patient attrition during the time that we are building up that relocation space. So again, to reiterate, ensure that we know exactly when our lease agreement is set to expire, and let's ensure that we are aware of the deadline we need to meet if we choose to express and exercise our option to renew if we have one under the lease agreement. So when should all of you begin planning for your lease renewal? When should you begin to proactively prepare for your lease negotiations and an upcoming lease renewal? Before you is something that we at Cirrus like to call the tenant lease cycle. And I would encourage you all to take some notes and take a mental picture of the tenant lease cycle so that you are all aware as to the appropriate and the best time to begin negotiations and preparations for negotiations with your landlord. The absolute ideal time to begin negotiations with your landlord is approximately 18 to 24 months, just about 2 years prior to the expiration or the renewal of an office lease agreement. 2 years prior to the expiration date or the renewal date of the office lease agreement. The more we wait and the closer we approach the expiration date or the renewal date of our lease agreement, the lower and lower our leverage in negotiations becomes, and the more leverage the landlord has on their side in the negotiation of your lease agreement. If, for example, we wait until about 6 months prior to the expiration date or a renewal date under the lease agreement, the landlord is well aware that it takes us longer, in most cases, than 6 months to relocate a practice or a clinic, and therefore has significant leverage in their side for the negotiation. Right? If we don't have any options to renew and we're only 6 months or so prior to an expiration date, the landlord could almost present us with any lease agreement that they deem fit. And if we are not prepared to relocate the clinic, we don't have a lot of choice but to sign what has been presented to us for the term moving forward, both in terms of economics, rental rates, etc., as well as the legal terms and provisions that are presented and submitted to us. So, to reiterate, the best time to begin negotiations and preparation for negotiations with your landlord is 24 months prior to the expiration or renewal of a veterinary office lease agreement. Again, extremely critical that you are all very aware of these dates, and ideally we set reminders for ourselves. In your day-to-day operations of the clinic, a lot can arise and it's easy to forget these critical dates. And again, it's so important that we begin this process proactively and strategically. Before beginning negotiations with your landlord, it's critical that all of you are aware as to what your value is to the landlord as a veterinary tenant. The majority, or all of you as veterinary tenants in your landlord's space, are one of, if not the most coveted tenants for commercial landlords. Veterinarians are loyal, tend to be long-term tenants, and landlords prefer longevity over revolving door tenants. If a landlord can attract a veterinary tenant and they know that typically the veterinary clinic stays in the same space for, in most cases, 30 plus years, they covet those types of tenants, and we have significant leverage to negotiate a favorable economic and legal lease agreement for their spaces. Your tenancy as a veterinary tenant guarantees a reliable source of revenue and security, and a steady income is extremely attractive to any landlord. Veterinary tenants have a very low default rate as it relates to rental obligations and as it relates to other types of tenants in the country, for example, retail or restaurant tenants. Veterinarians have one of, if not the, lowest default rate as it relates to the rent. And finally, veterinary clinics bring a significant amount of foot traffic to most commercial centers, plazas, or buildings. And this is extremely attractive to not only a commercial landlord, but also it's attractive to other tenants in the building and tends to increase the revenue and production of the entire shopping center, plaza, or building. So now that we have a little better of an understanding as to the importance of a properly structured veterinary office lease agreement, how is it that we bring the landlord to the negotiation table? Right? We've already learned that your landlord is aware that a veterinary clinic is an expensive and difficult to relocate business, which they tend to use to their advantage. We also know that most landlords will stall meeting or speaking with you about the negotiation of the lease agreement for as long as they possibly can in most cases. And we also know that the closer they can get you to the end of your term, your expiration date, the less leverage that you have to negotiate a favorable deal and the less ability you have to relocate the practice. We therefore need to somehow pique their interest with a strategic phone call, email, or voice message, typically requesting to discuss those items that the landlord really would like to discuss, which is, in most cases, rent and term. In most cases, so that all of you are aware, landlords will use rent as a diversionary tactic to prevent you from dealing with those key issues that are hidden in the rest of the pages of your lease agreement. Right? Those provisions such as the assignment article, which dictates and defines your ability to transfer the lease agreement to any buyer or successor in interest under your practice and lease agreement. The option to renew articles that you may have under your lease. Are they properly structured? Are they transferable to an incoming buyer of the clinic? It's so critical that these options to renew the lease are not solely personal to you or your corporate entity. They need to be transferable to any doctor who purchases your clinic, because in the majority of cases, if a doctor looks to purchase your clinic, they will require financing from a lending institution. If there is not a minimum of, say, 5, 7, or in some cases 10 years of guaranteed term on the lease, most lending institutions will not finance the acquisition of the practice because they don't have enough guaranteed term to amortize that loan over. Therefore, it's extremely, again, important that any options to renew the lease agreement that we may have are transferable and exercisable by any doctor who purchases our clinic or any doctor we transfer the lease agreement to. Do we have items in the lease agreement such as a relocation provision, which can allow the landlord to relocate your clinic within the building or the shopping center in order to make room for a tenant that they deem more desirable or who may be willing to pay them more rent. And what does that relocation article look like within your lease agreement if it exists? Is the landlord able to relocate you to a basement suite? Is the square footage of the space going to increase or decrease? And do we lose a treatment room, or do we have to pay more in rent because of the increase? These are all items that we need to be aware that could exist in your lease agreement and that need to be properly structured in order to support your goals and endeavors in the clinic. I would now like to dig a little bit deeper into one of the most important articles that will be found in your lease agreement, again, the assignment article, which dictates your ability to sell the clinic and transfer the lease agreement to an incoming buyer of the practice. I'll give you all a quick minute here to look through the article you see in front of you and think to yourselves, are there any red flags that I might highlight if I read this article in my lease agreement? And what is it that we can do to ensure a more favorable assignment article? For those of you who do have a copy of your personal office lease agreement, I would highly encourage you to look through your assignment article and make note of any potential red flags that you see within. Did anyone notice the writing flagged in red on the screen in front of you? It states that if the tenant should wish to assign or sublet the leased premises, it shall have first received the consent of the landlord. It then states that any request for consent shall be in writing. Now, unfortunately, it does not dictate within this article what we need to do in order to obtain the consent of the landlord. What must we do to ensure that the landlord will provide consent to a transfer of the lease agreement? It needs to be properly outlined and defined what that transfer process will look like and what it is that we need to do in order to obtain the landlord's consent to a transfer. Unfortunately, more and more often today or these days, we are seeing landlords across North America leverage consent to a transfer of the lease agreement in order to request, for example, proceeds of the sale of the practice, or an increase in rent for the incoming buyer of the practice. For example, they will grant you consent if you provide them with a percentage of the sale proceeds from the clinic, or convince the incoming buyer to pay a premium on the rental rates. Now you can imagine at the 11th hour of a purchase of the clinic what that type of problem may do to a deal. It goes on to state that the landlord shall have the option to either terminate the lease or to revise the minimum rent to be paid during the remainder of the term to the greater of the then current market rent for the leased premises, or 15% greater than the then current rent. So solely for requesting consent to transfer the lease agreement, the landlord now has the option to either terminate the lease agreement or revise the minimum rent to be paid. Now, again, you can imagine, all of you, what this might do at the 11th hour of a sale of your practice. So again, going back to the theme of today's course, it's so important to be proactive in ensuring we understand what is in our lease agreement and what needs to be amended proactively and strategically prior to thinking about transition or renewing a lease agreement. Moving forward, and unfortunately the majority of you will find a very similar assignment article in your lease agreements. As you can see, 75% of the leases that come across our desks here at Cirrus have this exact assignment article written within them, and it states in red here that the tenant shall not be released from its obligations under the lease and shall remain liable for any failure of the tenant or its assignees or subtenants to observe each and every covenant of the lease. Which means that even after we have sold the practice or clinic and transferred the lease to our successor in interest, the new doctor who purchased the clinic, we are still a guarantor for that new doctor, which means that if they default on rent or enter into any dispute with the landlord in terms of legal obligations, the landlord has the right to come after you in your retirement for the fulfillment of those obligations. And if, again, we have provided a personal guarantee under the lease agreement, either as a separate document or we've signed the lease agreement personally, it means that the landlord can come after your personal assets as well as the assets of your estate. Very important and ideal that we completely remove any continuous liability under the lease, and you are removed from any liability upon sale and transfer of the document. I'll give you all a quick second here to read through this option to renew article, which basically dictates that you have, if you have an option to renew article in your lease, you have the right, but not the obligation, to renew your lease agreement for a given period of time, most commonly 5 years. As you can see in this option to renew article, which again is found in 90% of the veterinary leases that come across our desks, it states that provided that Dr. Joe Black shall remain as the tenant. And this is that personal option that we had discussed earlier. When I see language like this in an option to renew article, this tells me that the option is personal to Dr. Joe Black and therefore non-transferable to an incoming buyer or successor under the clinic or lease agreement. It then goes on to state, and if the tenant duly and has regularly paid its rent and has performed its covenants and obligations under the lease and has not been in default. Well, unfortunately, there are some of you and some of your colleagues who will miss a rental payment, will miss the deadline, will provide a late rental payment. In some cases, you have an article within your lease that dictates that you must be in the practice, practicing for certain business hours throughout the week, sometimes on the weekends as well. And some of you may or may not be aware that the lease agreement can dictate those hours that you are allowed and must practice in the clinic. If ever we have operated outside of those hours, it is considered a default under the lease agreement. And any savvy landlord would likely use this when you approach them to exercise this option to renew. So it's very important that there is not language which is so restrictive in the option to renew provision that we can never have been in default of the lease agreement, because it does occur minor defaults from time to time. It then goes on to state that any such renewal of the lease shall be on the landlord's then current quote-unquote standard form lease agreement. I'd like to tell all of you in attendance today, there is no such thing as a standard form lease agreement, and it's important that language like this within an option to renew article is removed. If, for example, you are able to obtain a significantly favorable lease agreement that acts as an asset for you and the clinic, and when we renew the lease, it is on a new standard, quote-unquote, standard form lease agreement, what that means is all of the properly structured items that we had previously negotiated would go out the window, and we would be presented with a brand new, again, quote-unquote, standard form lease agreement. So this type of language is a significant red flag and needs to be eliminated from this type of article. It then goes on to state that in no event shall the rent be less than the rent paid in the last year of the original term. Well, I'm sure the majority of you are shaking your head, but you can imagine in the event of an economic recession or depression, or we experience a similar period as 2008, 2009, and rental rates decrease across the country, it's unreasonable for there to be language within this article that states that your rent cannot follow suit and therefore decrease in connection with the rental rates across the country. There should be no language within your option to renew article that states that your rent can never go down. It is unreasonable. And finally, it states that the rent shall then be determined by arbitration based on the market rent for renewing tenants in the building if the tenant and the landlord are unable to agree on the rent for the option period. Well, it's important that market rent is defined. The tenant's description of market rent and the landlord's description of market rent at the time of the renewal of a lease agreement may be very different, and it's important that it is specifically defined within the lease agreement how the rent in an option to renew period will be determined, and failing which shall be determined by arbitration, but it should not state language based on the market rent for renewing tenants in the building. A few of the other traps that we find in office lease agreements that all of you should take note of and be aware of, and I encourage you to look through your own lease agreements at some of these articles which you see in front of you, which can be significant traps for you and the clinic under the lease agreement, right? Unfortunately, for lack of time today, we are unable to cover all of the issues and all of those articles that are important to be aware of under a lease. But it's important that you familiarize yourself with those items that exist within your lease agreement and which may pose significant issues in the future. So what is the correct treatment plan for winning a negotiation? What you see in front of you is the Cirrus Consulting Group process for winning lease negotiations. It's an 8-step process, and it begins by gathering all documentation as it relates to the lease agreement. Any amendments, any riders, the original lease agreement, even if it was signed back in 1985, we need to obtain a copy of all pertinent documents that relate to the original lease. Secondly, what are your practice and career goals? Right? We need to know where we stand currently, where it is that we're hoping to go, and we need to develop a strategy in order to obtain those goals that we would like to obtain for the practice and throughout our career. Next, we need to review the lease agreement and all pertinent documentation for risks. As I mentioned, I would encourage all of you to personally go through your lease agreement with a highlighter. Make note of some of those items that you feel uncomfortable about or you have questions on, and ask those questions proactively prior to the expiration of your lease or upon the renewal deadline quickly approaching. Next, it's important to be aware as to what is going on in the market in terms of rental rates, property availabilities, etc., and prepare yourself with research so that you have science and numbers on your side to utilize in the negotiation of the economics, the rental rates of your lease agreement. The 5th step is to develop an outcome and a strategy for entering into the negotiations. Now, up until this point, what is it that we have not yet to do? We've gone through 5 steps in this 8-step process, and we have yet to reach out to the landlord. We have not called the landlord. We have not picked up the phone. Unfortunately, in most cases, we see your colleagues, decide that there are issues that they would like addressed in their lease agreement, and the first thing that they do is call the landlord and say, Mr. or Mrs. Landlord, I would like to negotiate the lease agreement with you. Well, again, most landlords are trying to push you as close to the expiration date as possible so that they have leverage on their side. If you call them and say that you would like to negotiate, most people do not want to negotiate, and therefore they will continue to delay the process. So it's important that you're strategic in that first phone call and you are extremely prepared and are being proactive. So we begin with the economic negotiations in step 6. We reach out to the landlord to discuss those items that they really want to discuss. What if the landlord received a phone call saying, Mr. or Mrs. Landlord, what rent would you like me to pay moving forward? It's a little bit of a nicer phone call to receive, and you have a lot more of a chance of receiving a return phone call and then beginning to discuss those items that you have perhaps concerns with under the lease. And then following that, we need to negotiate all of those legal terms and provisions which we have touched on today. Following the negotiation, when we are presented with the final lease agreement, the final document that we are ready to sign, it's absolutely critical that you re-review that document. You would be surprised as to how many times we complete a negotiation that has gone on for months, and the final document that comes back to us has none of the changes that we had negotiated. And if you're not careful and you sign that document, all of those negotiated items will go out the window. Some key takeaways just briefly. Start planning, again, for the renewal of your lease 18 to 24 months before the expiration date. It's not just about the rent. The rent is important. It's important that it is not unfair for the market. However, those legal terms and provisions are those items that could jeopardize the clinic, your ability to sell the clinic, and your goals for the clinic throughout the life of your career. It's about minimizing any risk that we have under the lease, maximizing our flexibility and clinic value, and achieving long-term peace of mind. If we have a properly structured lease agreement, we will certainly be able to sleep well at night, knowing that we are protected and the clinic is protected. We need to be strategic and proactive. Again, we don't start by reaching out to the landlord to begin negotiations. We need to prepare and take some real time to think about the strategy that we plan to enter into negotiations with. Again, do your homework and research. Ensure that you know what is going on in the market in terms of rental rates, availabilities. Do some landlord research. One of the services, so that you all are aware, that Cirrus Consulting Group offers for those of you potentially nervous about looking through the lease agreement on your own, or who would like a second set of eyes to look through the lease, or those of you who would prefer to focus on the clinical side of things. Cirrus does offer a critical dates and risk analysis. It is a $1,495 service, and what that entails is our legal, leasing, and consulting teams taking about 3 to 4 hours to analyze the lease agreement for any traps, following which we conduct some market research in terms of property availabilities in the area, rental rates, etc. And we will walk you through those items that we pulled out of your lease as potential liabilities, potential red flags, but also potential opportunities to improve the lease, and we will provide you with a strategy to effectively negotiate your veterinary office lease agreement. And for those of you in attendance today, the first 5 who tell me that they are interested in a lease review, critical dates and risk analysis, we are happy to provide the first 5 of you who either call or email me with a complimentary review of the veterinary office lease agreement. So again, if you have any interest in having a second set of eyes look through your veterinary office lease, if you either call or send me an email, we are happy to look through your specific lease agreement free of charge and walk you through the best approach to your upcoming negotiation. Alternatively, for those of you who have any questions, any specific concerns regarding your specific situation or case or lease agreement, I am more than happy to address any concerns, any questions that were not addressed in today's course. My contact information is up there in front of you. Certainly, please don't hesitate to reach out with any questions, or if you would like the complimentary lease review consultation. Typically, if we had time, I would address some questions here in the chat room. However, due to the limited time we have available here, again, if you have any questions personally, please do not hesitate to either call or email. I'm happy to provide some guidance. And again, the first 5 of those of you in attendance today who would like a complimentary critical dates and risk assessment, we are certainly happy to provide that as well. I would like to thank all of you very much for joining us this morning on the West Coast, this afternoon, perhaps on your lunch hour on the East Coast. I really do hope that you found the content valuable and insightful, and I hope that all of you in attendance have a little bit more of an understanding as to how important the lease agreement is for you and your practice, and a little bit of a better understanding as to the importance of proactively and strategically approaching a lease renewal and negotiation. Again, thank you all so much for joining, and I hope that you all have a wonderful afternoon or rest of your day.